Okay, so apparently I'm moderating, so this should be interesting. What we propose to do is go across and start with Alain and move across, and each of us will give, I assume, something like a 20-minute discussion, discourse presentation. I would prefer that we have more of the dialogue. I'm not a fan of any talking head. And there's a lot of capacity in the room. There's a lot of people here with a lot to say, a lot of insight, and I think that would be more useful. So I think that's our focus. Yeah, and of course, as always, acknowledge our presence in unceded Torres Strait territory, Masicho, for being here, and acknowledge you for attending. So, Alain, I think we'll start with yourself, and can go from there.
Thank you. I'll talk about corporations using the system of law as a weapon against citizens, let's say journalists or intellectuals or anybody that talks about an issue, and that not really has mean to defend himself or herself in a courtroom. We usually talk about SLAPs, strategic lawsuit against public participation. And I will do it because I had in the last years to think a lot of this system, legal system, even though it wasn't my field as an academic, because I was sued for a book I've written, Noir Canada, for $6 million from Barrick Gold, and for $5 million from Bango Corporation. So $6 million from Barrick and $5 million from Bango, so it made $11 million. A daily newspaper in France, Le Monde, said it was the most expensive book of the history. Just to settle things, Noir Canada is a book that was released in 2008 by Éco-Société, and it was basically an analysis of plenty of sources about cases of abuse attributed to Canadian corporations, mainly in Africa. And basically the book was presenting Canada as operating like an offshore state with respect to the mining companies, because as we know, 75% of the world mining corporations are Canadian, and if it is so, it's also because a lot of investors in the mining sector aren't from Canada, but they choose Canada from around the world to register companies that will operate also abroad. And it makes Canada exactly a country like the Bahamas for the banking sector, or the Turk and Caicos Islands for the insurance sector, and so on and so forth. It's a state that, in a way, gives its sovereignty to a specific industry, at least on a legal and jurisdictional point of view. So the book I've written was the object of the lawsuit, and we had, after 4 years, to withdraw it. I'll be able to talk about that later on, so that the lawsuit would stop. But during 4 years, we were able to present the books, to sell it, to make a political debate out of it. And after it was withdrawn, I wrote right after another one. It was basically the same book with another cover, which was Paradis sur Terre, and it was translated in English under that title, Imperial Canada Inc. And I'm proud to be able to talk about this book in Vancouver, since the publisher is also in Vancouver, which is Talon Book. But I'll be talking here more about the experience of being sued. And not about my personal experience only, but about what I could hear of from people who experimented the same thing, and about what we're able to see as someone being in that position during all these months. And I call that my 1,000 days journey in the country of law. And it made me make some discoveries about some reality of the system. And I'll be quite direct in the way to put it. The first thing I would say is that the law system is corrupt. And when I say that, I don't really think or directly think about brown envelopes that some people would give to judges. It's not in that way I'm thinking about it, but I'm thinking about it with respect to money. Money corrupts the legal system because it is everywhere. Everywhere in the proceedings. I mean, every moment of a proceeding, every moment of a lawsuit is led by money. Money is in the middle of all decisions. Will I sue someone? Will I go to appeal? Will I call some experts? Will I give some documents? Every aspect of the legal proceedings are related to money. Not only the money we have or have not, but the money that the other party has or has not. If it lasts long, maybe I'll be able to use the legal system to crush the people because we know in front that they don't have the money to support a long trial. So we'll use all what we can so that it will last. So, and in the result, you'll never see money being mentioned in the decision of court or in the out-of-court settlements or whatever you can imagine, but money is always in the center of it. And we could say that there's a notion in law that is absolutely crucial and that we hear every day in a trial or in the proceedings, and which isn't really related to law, but to economy, and it's the notion of client. A lawyer doesn't represent a citizen, but a client. And a client, the notion of client isn't really a legal one, but an economic one. A client is someone that has the means to have access to some services or goods. And, well, if you're not able to be a client, you don't have access to justice. That's as easy as that. And when you're dealing with lawyers, I mean, you're not dealing with people that work on minimum wage. But they are, I mean, they are asking $400, $500, $600 per each hour, and it can last and last and last, as we know. So this is the first problem, the money. The problem of money is also, and I'm still at my first point, it's also about the fact, I mean, something quite unfair here for the general public is that all taxpayers finance the legal system, but only the ones that have the means to pay the supplement that the lawyer has may have access to it. But we all pay for it. It's a bit like if only 10% of the population could get access to public health service, while we would all pay for them. It's exactly the comparison we could make. The second point is about law not being that rational. I mean, of course, in law there are doctrines, an apparent logic at least, intellectual ground, I mean, a tradition. I mean, it's not meant to be irrational when you look at it in the on the first place. But in fact, in an unequal relation with corporations that can use the system just to destroy someone, financially or psychologically, law is meant to frighten. I mean, when you have someone knocking at your door at 7 in the morning to give you an official legal paper, you're not thinking about legal rationality. I mean, when people get at you and talk to you about your lawsuit because you were mentioned in the paper on the daily, on a regular basis, they won't talk to you about jurisprudency or doctrine, but they will fabulate a lot of things. I mean, I remember someone saying to me, well, Barrick Gold will make it impossible for you to talk, as if a corporation had that power. I mean, of course, it will be at least a courtroom that, on the basis of law, will say something about, I mean, what's allowed or not. but it becomes totally irrational, and we see it very well in the famous novel of Franz Kafka, The Process. And what is interesting in The Process is also, when we read it in German, is that there are two terms to talk about the trial. The trial, I think we say, I'm sorry, I have a hard time talking about these technical terms in English, but the trial in German, der Prozess, there are two words in the novel to talk about the trial, and I know that in the French translation we only kept one, which is le procès, but it's a pity, because there is the trial, der Prozess, as being the trial, and also das Verfahren, which is the proceeding. And if we look closely to the novel, we see that actually it's not a trial that is a problem for the character, but it's the proceeding, it lasts. And so there's something going on around the person that is sued that just makes the life impossible. I have to go quicker. In sort of a relationship between a corporation and an ordinary citizen, we could think that there are two steps. First of all, the trial, and then eventually, maybe in some cases, a punishment. But in that kind of context, the trial is already a punishment. So the corporation achieved its goal just while launching a lawsuit. And it can be without any legal base, but the simple fact of being sued is already a punishment. I go faster. I think I won't have time. It's interesting also to see the difference is not only related to means, but it's also related to the status. When a writer like I am is being sued, this person remains a physical person. I mean, I think that I is enough healthy to know that when I'm somewhere, I'm not somewhere else, that I have 24 hours in a day, and I have a certain amount of energy, and so on and so forth. But a corporation is not, as we say, a legal person. Joel Bakken, people like that, wrote a lot on the problem of this legal status of corporations being persons. I mean, they are persons, they are nobody. And they are nobody being represented by anybody. And a corporation may be anybody that represents it. So a corporation can be in 5 trials at the same time, making an exhibit somewhere, selling goods, signing contracts, digging, polluting, everything we've mentioned. It's a machine. I mean, it's a monster. It's something like more mythological. You have in front of you just like figures that are multiplying, and it's hard to be like in front of that sort of a machine, because if they want to stop you, they stop you as a person, but the proceedings they are in don't stop them. But if I, for instance, if a person would sue a corporation, it couldn't be the same. About the ideological and cultural basis of the legal system, I mean, justice may be the last reserved domain of the bourgeoisie in terms of a cultural milieu tradition of the 19th century. It's very old-fashioned. And so you have very old values and traditional values that are taken into account in a courtroom. I mean, I remember I was told by my lawyer to quote the UN reports instead of Africanists that work on very important issues in Africa, as is the UN expert had more to say than these critiques of the behavior of mining corporations in Africa. Why is it so? I mean, in my classroom, I will never tell my students that it's better to quote the UN than Verschav. But they will. But we have to, because the UN is better, in the hierarchy of references, because it's a bourgeoisie courtroom. So if you say to a judge, the UN said it, it's very serious. But if you said, well, this Africanist that France you don't know said it, they won't necessarily buy it. If you're a Westerner, if you come from the Western world, it's better if you come from the Southern world. If you're a professor, it's better than if you're an activist. If you work in a big organization, it's better than if you work in a small one. If you're old, it's better than if you're young. If you're a man, it's better if you're a woman. If you're well-dressed, it's better if you're being sloppy. One of the problem, I have 20 like that. I mean, I will stop here. The last one, one of the problem also we can face when we're just this ordinary guy going in a courtroom is to see that, and this is a real problem. When I say that to Frenchmen, they don't believe me. But here in our system, judges are former lawyers, and I mean, if you study it, it's incredible. I mean, it's just simply not serious. Because judges, in reality, come from these big, powerful law firms. I mean, one day the Minister of Justice pick up the phone and calls the lawyer that is in a big law firm that gave a lot to the party usually, and says, well, wouldn't you like to become a judge? And you see that person becoming a judge. So what does it mean? It makes the big law firm part of the legal system because they provide judges. So it changes a lot the relationship you have with a party when a corporation will be represented by one of these lawyers. It doesn't mean that you will lose, but I mean it changes the dynamic totally. I mean, we wanted the courtroom in Quebec to say that the lawsuit shouldn't be considered by the system. But if you have in front of you someone that cannot be presented as being abusing of the legal system on political purpose because he's part of the system, it will be damaging the reputation of the system as a whole. Well, you know that you're not in a good position right at the beginning. And as I said, I could go on and go on. Usually I talk about that for 2 hours. But I could just say at the end that I don't want to present things as being a matter of discouragement. I just want to put out that usually, I mean, I do encourage, courageous lawyers to sue corporations and to use the legal system as much as we can. But I don't trust that system at all, even though I think we can use it more on a political basis and are also more to make, to raise awareness on some issues. And I think that it's the law, the legal system represents strategic tools. And I'll talk about being sued, and because I know that it's a concern for many people here, being sued or not, and I would just say that when we're in a position of when we are sued, we know that the struggle is about who will be the example of whom. The corporation that sues citizens, they want to make them an example to all the others, saying, if you talk about us in a critical manner, it will happen to you what's happening to these person that dare to do that. And the response is for people who are sued to sue the corporations in general. If you sue people like us, it will happen the same thing that happened to Barrick Gold, and you'll have bad publicity.
Good morning, my name is Rachel Aris. I really appreciate the welcome that Audrey gave us yesterday and the day before, welcoming us onto Musqueam territory. I'm honored and humbled by being invited to speak here among people who made so many contributions. I'm from a settler family. I work as a professor and my education is in law. Some of you have heard about the Kitchen Mikusig and Inawa people, also known as KI, and their struggle against Platinex, the mining exploration company that flared into a legal dispute in 2006. As I was living in Thunder Bay at the time, I was able to attend the KI and Platinex hearings, and I met several people involved in the struggle. The story of KI's struggle for self-determination is long and complex, and it goes beyond Canadian law, and it is continuing. There are many aspects to this story other than the legal aspects. But today, however, it's the legal aspects that I'm going to talk about, and the role of Canadian law in KI's struggle for self-determination. I hope that this story will help us to think about the various and contradictory ways in which Canadian law can both support and limit Indigenous land rights. So the idea that it's something we can use is something that I want to see if we can bring forward from telling this story. Kitchener-Nakussi-Bininawak is a small, remote First Nations community on the shores of Big Trout Lake, 500 kilometers northwest of Thunder Bay, which is on the northwest shore of Lake Superior. It's a flying community most of the time. There's a winter road over the ice for 6 to 10 weeks of the year, depending on how cold it is. Big Trout Lake is a headwater lake that flows north into Hudson's Bay. KI's traditional territory encompasses much of the watershed of Big Trout Lake. Many people in this community continue to hunt and fish and depend on the land to survive. My focus is the legal dispute that took place in Canadian courts, but it's really important to understand that there are 3 legal systems that converge on KI's land. The first and most central is KI's own law, which arises out of the community's relationship with the land. As KI community members explained in their affidavits before the court, the land itself and the community's relationship to the land is sacred. John Cutfeet, then a spokesperson for KI, explains the concept of Kanawan Dandapi, to protect and keep the land. This is understood as a sacred duty, and fulfilling this is part of community responsibility and identity. For the people of KI, a full understanding of their own law comes from spending time on the land. To be on it is to understand it, to understand its connection with the people, and that's part of protecting and preserving it. The second legal system is the Crown's duty to consult and accommodate. This duty is a process that is meant to fulfill Section 35 of the Constitution, which recognizes and affirms Aboriginal and treaty rights. The duty to consult and accommodate is triggered by Crown knowledge of an Aboriginal right or claim that might be impacted by its activities. Consultation and accommodation is supposed to reflect the honor of the Crown, and it's supposed to be meaningful. To be honorable, it has to take place before the Crown's proposed activity. There has to be enough time, and maybe even financial support for the Aboriginal group affected to respond meaningfully. Processes have to reflect the intention to substantially address Aboriginal concerns. And the court has said that in most cases, the Crown will have to change its plans based on concerns raised and knowledge gained through the process of consultation. This is the accommodation part, and this is why it's important not to separate the two when we talk about it. It's the duty to consult and accommodate. A more recent legal development is that consultation is not necessarily limited to immediate impacts on Aboriginal treaty rights, but it applies, hopefully, to overall projects and maybe to strategic higher-level decisions. There are, of course, significant drawbacks to the duty to consult. The most limiting aspect of the duty to consult is that it does not recognize an Indigenous people's veto over Crown activity on their lands. While the courts encourage negotiations, actual agreement is not required. Some other key concerns, of course, are that the duty to consult centers Crown visions for land use, so it doesn't support Indigenous aspirations or support cooperation between Indigenous groups and the Crown, but simply requires Indigenous groups to respond to Crown plans. Finally, the duty to consult and accommodate provides the government with a mechanism to constitutionally justify encroachment. As it justifies such encroachment, the duty may whittle down Aboriginal groups' access to land until nothing is left. For all its weaknesses, however, the duty to consult is in sharp contrast to the mindset of extractivism, which is found in Ontario's Mining Act and in many provincial mining acts, and this is the third legal system that was encroaching on KI's land. The extractivist worldview manifests through law, particularly in the free entry approach to mining. Ontario has a free entry system which opens up all Crown land, even that subject to Aboriginal land claims for staking and prospecting. In Ontario, at the time of the dispute, all a prospector had to do was stake and file a claim with the ministry, and then they were free to work that land, to to exclusively have the right to do exploration there and to get any profits that might come if a mine was developed. So that was the convergence of law at that time. In January of 2006, Platinum began early explorations on mining claims it held on KI's traditional territory. Platinum was acting on its rights as set out under the Mining Act, which made no mention of Aboriginal treaty rights at that time. Platinum had communicated earlier with KI, and the community had decided that it was not interested in mining. KI issued moratoria against mining in 2001, and again in early 2006. When community members discovered Platinum's drilling camp in February, they acted on their own law, Kanai Dundaki, requiring them to look after their land, as well as on their understanding of Treaty 9 as a document of sharing rather than a document of cession, and they set up a protest near the exploration activities. Platinum left, suing the company for $10 billion, suing the community for $10 billion in damages and asking for an injunction to remove the people from the exploration site. So you can see here the confidence with which Platinum acted based on rights it was given through the free entry mining system, both in going onto territory where they knew they were not welcome and in pursuing such egregious damages.
Did you say billion or million?
I said billion. Yeah, I often have to say that twice. This engagement with the power of the formal legal system in this very punitive, very bullying way crystallized the conflict between these three legal systems on the land. At the first hearing into the dispute, the judge ordered a 5-month injunction against Platinum. Surprise. This decision was both a victory and a defeat. The injunction against Platinum was a victory in that lower court judges had not been ordering injunctions against developers in similar situations. The injunction meant that the duty to consult and accommodate and the requirement that it be done prior to any rights infringement had to be taken seriously. The decision was based on the finding that KI might suffer irreparable harm due to its loss, the potential loss, of its connection to culturally and spiritually significant land. The court said, the land is the very essence of their being. It is their very heart and soul. No amount of money can compensate for its loss. Aboriginal identity, spirituality, laws, traditions, culture, and rights are connected to and arise from this relationship to the land. This was an important opening to understanding the source, the real source of what has been kind of corrupted into Aboriginal rights. The real source is Indigenous land rights, Indigenous attachment to the land. And that is what was actually being recognized and protected in Canadian law in this granting of the injunction. The judge also found a public interest in encouraging the Crown to fulfill its duty to consult and accommodate Aboriginal peoples. This was important because in most injunction cases, courts see economic interests as sort of the automatic equal of the public interest. The public is assumed to always have an interest in potential jobs, open trade, extraction of resources. So that was a change to see the public interest displayed. Yet the injunction was also a defeat. The injunction was granted on the condition that KI Ontario, who had not been involved in the lawsuit at this point, and Platinex engage in consultation, and I quote, to allow Platinex to conduct its 2-phase drilling project at Big Trout Lake. Here you can see that the judge was unable to imagine that consultation and accommodation might possibly provide information that could prevent the drilling from happening. While the judge appeared to understand most of what KI was expressing in court, this condition begins to close the opening found in the judge's recognition of KI's perspective, as it points consultation towards the specific end. This is precisely the risk of the duty to consult and accommodate, that Crown visions for land use are seen as inherently sound and simply require adjusting to make sure that Aboriginal rights are accommodated. In May 2007, the judge found that some consultation had taken place and imposed an agreement on KI to allow Platinex onto the land for specific drilling. So this really closed the opening that was found in the earlier decision. The issue was narrowed to the scope of the duty to consult and accommodate. It left out ideas of public interest, and it left out KI's own community consultation protocol, which included a veto. Although the judge continued to acknowledge KI's perspective on their connection to the land, he was unable to connect this perspective to something he called a recognizable legal right requiring protection. So the community decided that they were not going to allow Platinx onto the land. They gained support for their position from First Nations across Treaty 9 in Northwestern Ontario and some environmental and social justice groups at the time, Canadian Wildlands League, Mining Watch, Eco-Justice. So this mobilization had been building since the filing of the lawsuit against KI. Platinx then asked the court to allow it to start drilling and order the community to do nothing to prevent it. KI stated it could not afford to defend this motion anymore, released its lawyer and left the courtroom. The judge proceeded to rule and made the order as Platinx had requested it. I think I might have to go faster here. In December of 2007, Platinx brought KI to court for contempt on this, and KI had made several statements that they would not allow Platinx to drill. On this basis, the judge found Chief Donnie Morris and 5 band councillors in contempt of court. This finding wasn't contested. Chief Morris explained that he did not mean to disrespect the court, but that KI had to follow their own law, as well as their understanding of what their rights were under Treaty 9. In March 2008, the judge sentenced Chief Morris and the rest of the KI6 to jail for 6 months. The judge emphasized the rule of law as expressed in court orders. Public defiance, especially of court orders, cannot go unpunished. The rule of law meant that the court had to uphold Canadian law. If there were 2 laws, one for Aboriginal people and one for non-Aboriginal people, the administration of justice would fall into disrepute, and there would be chaos. Of course, we all know there's already 2 separate systems of justice that tend to be applied in criminal law particularly. But anyway, this is what the judge said, and the result was that the KI6 had to be jailed. The Thunder Bay courtroom, designed to hold about 125 people, had standing room only on the day of sentencing. First Nations people made up the majority of those attending court that day because that is where awareness had first grown. They heard the judge say that they misunderstood their treaty rights and that they only had the right to be consulted. They watched their community leaders, ordinary people, being taken to jail. They saw very clearly that there were already 2 systems of law, one permitting governments to ignore their treaty promises and constitutional duties, and one that jails Indigenous leaders for standing up for their rights. People were angry, they were weeping as they waited outside the courtroom for Chief Morris and the others to be taken to jail. So there was already a lot of community attention, and this galvanized media attention, and it really pushed social and political mobilization across Indigenous and non-Indigenous communities. Law was so clearly delivering injustice that day. So at the time of the jailing, cross-community social mobilization bloomed. KI had built an alliance with the Ardok Algonquin, who were resisting a similar encroachment by a junior mining company on their territory. The KI6 and Bob Lovelace, who had already been jailed for contempt of court, became known as political prisoners and prisoners of conscience. So this was no longer a private dispute over access to land, which was how it had started. Platinx's invocation of the blunt instrument of law, like the corporation Zalan refers to, revealed the carelessness of its approach to exploration on KI's territory. It revealed the absolute foot-dragging reluctance of the Ontario government to fulfill any constitutional duties towards Indigenous peoples. And finally, it revealed the injustice of jailing protesters who held Aboriginal and treaty rights. Okay. I'm going to jump forward, I think, to the next legal event, but there was a very important protest that was organized by the people of Grassy Narrows who were protesting logging in concert with the KI6 and the Ardok Algonquin, and it ended up being supported. It was led by those 3 groups and was supported by a really wide coalition of social justice groups, trade unions, churches, local MP, Howard Hampton. The next key legal event was the appeal of sentence. It was scheduled to be held in a room that held 17 people. Once they saw the lineup outside the court waiting to begin, they shifted rooms and they managed to get one that held, I think, not quite 50. There were still a lot of people outside who stayed outside of the court all day. Many of us know, of course, that Canadian law, especially around issues involving Indigenous people, is rarely just. But despite the corruption of the law, despite its obvious problems, I think there's still an important desire. to see that law be just, to make that law more closely reflect a vision of a just relationship between Indigenous and non-Indigenous people in Canada. Being there, I think, sends that message that we want to see the law reflect justice and we want to see it reflected in a public way. The Court of Appeal ruling released the jail leadership, stating that the sentences were too harsh. It explained that the concept of the rule of law was much more than simply following court orders. The court said that the enforcement of the injunctions by imprisonment could not help but emphasize the estrangement of this community and Aboriginal peoples generally from the justice system. The use of incarceration as the first response, right, to the breach of the injunction dramatically marginalizes the significance of Aboriginal law and Aboriginal rights. So it's a much more open ending than that was offered by the sentencing decision. It's of course not perfect, but it was an indication that day. So what lessons, what can we maybe gather from the legal aspects of the dispute between KI and Latinx? Courts do make statements that recognize Indigenous law, that recognize an alternative, clearer vision of justice. These statements can be used legally in future cases, but perhaps more importantly, to support political mobilization towards respecting Indigenous rights. The judge's statements in the first hearing in the KI case, that the land was the heart and soul of the community, and that no award of money could possibly compensate for the loss of that land, showed that Canadian law has the capacity to see land as something other than an economic resource for extractivism. And this statement was mobilized in a way that supported the power of First Nation communities in Northern Ontario to speak out and continue their struggle. We also learned that legal change is not enough. One of the things that the Court of Appeal said was that Ontario's Mining Act was a remarkably sweeping law. And that kind of, 1 week later, the Ontario government announced that it was going to make amendments to the Mining Act. What legal decisions in Canada's adversarial system does is that they clarify who has power and who does not. In that way, law does seem to act at the behest of capital. At the same time, legal decisions sometimes vindicate the powerless. They sometimes protect those in need of protection. Sometimes legal recognition of certain arguments can contribute to a long-term change, such as the recognition of Aboriginal title in the Calder case in 1973, or even the openness to an injunction in the KI decision, in the first decision. Overall, the law tends to support the status quo, those that have power, and for the most part, retain it in a court of law. This clarification, however, that the law is not just, can contribute to social action, to political action, that might hopefully eventually lead to greater self-determination for Indigenous groups. It's really important to remember that KI did not choose to go to court, but felt they had to defend themselves against a lawsuit that was meant to threaten community solidarity. The adversarial legal system is not often the chosen path for those working towards Aboriginal self-determination. It takes a lot of monetary, community, and personal resources. What is important is that when the courts do get involved, conflicts become highly visible, and so do Indigenous peoples' own laws and perspectives. The visibility and injustice of the legal aspects of the conflict can sometimes work in favor of Indigenous peoples. In this case, the application of the duty to consult and accommodate gave the community breathing space following that first hearing and protected their land from harm for at least the duration of the injunction. Governments and proponents were told that consultation and accommodation had to be taken seriously, and that the government should change the Mining Act to recognize this duty. These are significant changes. Ontario's new Mining Act now requires consultation and accommodation before certain mining exploration activities, but not before claim staking. This is an improvement because it provides an opportunity for Indigenous voices to be heard in the process, but I don't want to overstate this. It's not the right to say no, and it does not recognize Indigenous land rights as based in specific ongoing relationships with land, and it does not end free entry mining. Following the Court of Appeal decision, Latinx tried one more time to access their mining claims, which were on kind of a small arm of Big Trout Lake. People from KI went out there and circled in boats and canoes, preventing the float plane from landing. Latinx then sued the Ontario government for damages, eventually settling for $5 million, this was an M this time, $5 million, and a guarantee of future royalties if a mine was ever built there. Finally, Ontario unilaterally withdrew the area of Platinum's former claims from open staking. Although these lands are protected from claim staking for now, this can be changed at the whim of the Ontario government. So through the twists and turns of the legal dispute, I think what I want to say is that it was the continued commitment and action of the community to defend their territory and insist on their exercise of jurisdiction that finally made their no to Platinum and to Ontario effective. As for the rest of us, maintaining social awareness of the continuing injustices against Indigenous people in the name of resources extraction, maintaining the pressure for political change is necessary to make these very slim openings that are provided by law worth the effort and the deep sacrifice that they cost. Thank you.
Hello, my name is Corey Wanless. I work at a law firm called Clifton-Steins Barristers and Solicitors, and we are lawyers for 13 Mining Chi in a lawsuit against Canadian mining company Hudbay Minerals for very serious human rights abuses in Guatemala. Many of you will have met Angelica Chok. She is our client, and to me, she's a constant source of inspiration and strength. She's really one of my heroes, and it's an honor to be one of her lawyers. I work with Murray Klippenstein, who's the lead lawyer on this case. He couldn't make it today, and also Graham Russell of Rights Action. He has been absolutely key in this lawsuit. He's been working with communities in Guatemala for years, and he provides so much support and energy and hard work, so I want to acknowledge his efforts as well. We can maybe go to the next slide. So this is Rosa Elvira and her fellow plaintiffs from the community of Lote Ocho, which I'll mention a bit more later. But I want to start by just saying a few words about Canadian mining in general. As people in this room are well aware, Canadian mining does not have the best reputation. There's been examples of fairly recent killings of those in opposition to mines in Guatemala, in Honduras, El Salvador, Mexico, and Colombia. There's been rapes and killings associated with Canadian mining in Tanzania and Papua New Guinea. There was a massacre in the Democratic Republic of Congo. And there's infringement of Indigenous rights and environmental harms all over the world. And again, all linked to Canadian mining. That's the one common denominator. There was a report that was commissioned by the mining industry itself, by PDAC, which is the Prospectors and Developers Association of Canada. It's when they were trying to oppose Bill C-300, which was a fairly weak bill, which would bring a small bit of accountability. And as part of that, they thought, oh, maybe we should get an idea of how bad things actually are. And then they commissioned this report, which was eventually leaked. And that report concluded that Canadian mining companies are the worst offenders of environmental, human rights, and other violations of any nation on earth. And then the quote was, of the 171 companies identified in incidents involving mining and exploration companies over the past 10 years, full 34% were Canadian. So we are punching above our weight. And there's some common themes to these incidents. One of them is the targeted killing of community leaders. That's what happened to Angelica's husband. He was a teacher and a respected community leader, and he was killed because of that. There's the forced displacement of Indigenous communities from their homes. Again, that happened near El Astor to Angelica and her communities. And then another theme is rape committed by security personnel. And again, that happened in Guatemala. Perhaps the highest profile example of this is Barrick denied for years that its security forces were raping women in Papua New Guinea. And they were confronted with report after report about this, and their strategy was to attack those who spoke out against them until eventually, when Human Rights Watch issued yet another report about the same thing, they acknowledged, oh yeah, maybe that's been happening, and very belatedly started to respond to it. The question that I want to answer today, or at least start to answer, is that if something goes tragically or catastrophically wrong at a Canadian mine, that's located outside of Canada. What can Canadian law do about that? Is it possible for there to be a lawsuit in Canada that starts to help remedy these harms? And that's the case if there's security forces committing human rights atrocities, or a community leader, or there's environmental damage. Can we do anything in Canada? What legal tools are available, and is there any way for communities and individuals to seek redress? And my answer today is a qualified yes. So far in the Hudbay litigation, we've managed to negotiate a number of procedural hurdles. And for the first time in Canadian history, there is a lawsuit against a Canadian mining company proceeding in Canadian courts. And I'm pleased to say that in large part to Angelica and her co-plaintiffs' persistence and commitment, there's nothing really that Hudbay can do about it to avoid a trial. They tried, and so far they failed. And that's, I agree with all of Alan's criticisms of the legal process. There are major problems with Canadian laws and our court system. That said, in certain circumstances, if you're lucky, if you're persistent, it actually affords individuals quite a bit of power. And Angelica is a testimony to that. So I'm going to explore this topic first by describing a bit about our clients and key allegations in the lawsuit, and then talking a bit about the formidable hurdles that were erected and that we managed to get around, at least in this case. And then talk a little bit about the future of corporate accountability in Canada. So there are three related lawsuits that are proceeding at the same time, and all relate to the Phoenix mining project, which is located in Guatemala near Lake Izabal, near a town called El Astor. All relate to the same mining project, a nickel mining project. And at root, the struggle for our clients is a struggle about land. This is a land conflict. Our clients have long maintained that they have historical, moral, legal rights to the land based on their status of indigenous people. The mining companies, and there's been a series of them, they rest on very narrow legal rights. They say we have a bit of paper from the Guatemalan government that says that we have the right to be here, so we don't even have to engage on any of those other questions. Even when the bit of paper itself is challenged, as is in this case. And as many of you will know, Guatemala's had a very violent history. Its government has treated its indigenous people atrociously. There was the bloody civil war in Latin American history in Guatemala. To call it a civil war is a bit of a misnomer. It wasn't. The vast majority of atrocities were committed by the Guatemalan state, and the vast majority of people who suffered from these atrocities were indigenous people. And in fact, the UN Truth Commission concluded that a genocide had actually been committed against the indigenous people in Guatemala. So it was in the context of that the bit of paper was first granted to the Canadian mining company that says, oh, actually, you can have this land. And the Canadian mining companies that went in later, they don't want to talk about that. They just say, well, we have a bit of paper. And so the communities near El Astor in 2006 joined communities that were already on the land and engaged in land reclamations. And that was the source of the current conflict between first a Canadian mining company called Sky Resources, which was a small exploration company based out of Vancouver, and it was later bought by, merged with, became one company with Hudbay Minerals. In 2007, there were forced evictions that were sought by the Canadian mining company at the time, Sky. It's funny, they said different things depending on who they were talking to. When they were talking to their investors, they said, don't worry about these land reclamations because they're on land that we don't really need anyway, or we don't need it for several years. So don't worry about it, it doesn't affect the bottom line. When they were talking to civil society in Canada, to human rights groups, environmental groups, they said, we care about human rights, we care about dialogue, we're going to resolve this by talking. In Guatemala, what they did is they immediately sought forced evictions with men with guns to evict people from their villages. And so in 2007, there was a series of violent evictions that involved houses being burnt to the ground, and that involved goods being stolen and smashed, and in the community of Los Teocho, involved the gang rape of 11 women. If we could go to the next slide. And this is a photograph that was taken at one of the evictions, not the eviction of Los Teocho, but one of the other communities, of what the company later described as a peaceful eviction. And this is a photo of Rosa Elvira, I might actually try and show just a very brief clip from the film Defensora, because I think it's important for Rosa to speak and to have her voice heard.
سليم شاف أهله كانوا مشهورين من ساق ويساش أحد من ساقي entonces anisa kawana kamano an validayna شكون كانها امبرس لأن أنا هون جوع جو شقولي ريلات ويا كتير ما جينا تسكتي جوري بتقول شقول ما سرعش شقولي تقول هذا الرجل شيء شو بس من ده شو ما جيت أنا سرقة جون يبقى كل أنا كنت لونس من زياد ما كنت كريستيان وبقول ولا جون بس ليه
So the first lawsuit relates to Los Teocho, and that's 11 women are suing for gang rapes. Rosa and Margarita, the two women who were most prominent in that cut, were chosen by the other women to be spokespeople, and have been carrying out that role quite courageously. The second lawsuit is Chalk and Hadley Minerals, and next slide, of course, as we know, this is Angelica Chalk. In September of 2009, during a community protest, her husband, who was a community leader and teacher, was surrounded by mine company security. He was hacked with machetes and he was shot in the head. And so if you show the next photograph, this is Adolfo. And I apologize in advance for the next photographs that I'm going to show, but I do think it's important. These are photographs that were taken after he was killed by a cell phone, and they show both his machete wounds and the gunshot wound that killed him. On the same day that Adolfo Each was shot, Herman Schub, who was the young father, was also shot. The bullet tore through his shoulder, smashed into his spine, tore through his lung as well, smashed through his spine, and he's now paralyzed from about here down. And in fact, you can actually still see the bullet, which is lodged next to his spine. I do want to acknowledge that this lawsuit is in many ways only a small part of a longer struggle that's been ongoing for a while and will continue despite whatever happens in this lawsuit. It is I think it's a powerful tool and it's a tactic, but even if we do have to recognize that even if it's fully successful, the struggle continues. And I believe that's how the community sees it, as only sort of one smaller part of a larger struggle. And in fact, there's more than one legal proceeding going on at the same time. In addition to this civil lawsuit in Canada, which is a claim for reparations for harms done, there is also a criminal proceeding that's ongoing in Guatemala. The civil proceeding is against the company, Hadley Minerals, whereas the criminal proceeding is against a guy by the name of Miner Padilla, who was the head of security at the mine for killing Adolfo Each and for the shooting of Herman Schub. And in fact, his trial is set to open after many procedural delays. It's set to open in just over a week in Guatemala. It's remarkable that that prosecution has gotten this far. My fingers are crossed, but I am very worried about that lawsuit. Unfortunately, Guatemala's legal system is still often dysfunctional. There's a lot of people working in the Guatemalan legal system who try very, very hard, but in order for a legal system to work, everybody needs to do their job properly. And if just one person doesn't, then you are not going to have a just result. So fingers are crossed. There's a lot of stuff going on in Guatemala, though, that isn't great. There was a fantastic head of the prosecution, Claudia Paz. She was a fantastic woman, really courageous, really making great strides in Guatemala's legal system. She was removed precisely because she was doing such a good job. So things get small steps forward, small steps back, and I'm hoping that this might be an example of justice in Guatemala that they do sorely need. I will speak just very briefly about the hurdles that we've gotten over to date. The first is about jurisdiction, and I want to clear something up, which is Canadian courts have jurisdiction to hear claims against Canadian corporations, regardless of where the harms are felt. Always. If a Canadian corporation is headquartered in Canada, it can be sued in Canada. That legal principle is so clear that Hudbay didn't even try and argue it. Instead, they used a doctrine known as forum non-conveniens, or which is the more appropriate forum. And in that case, the courts recognized that in certain cases there might be another jurisdiction that is sort of better suited to hear it. And that's the legal doctrine that corporations rely on all the time to try and get out of lawsuits in Canada. And in fact, I will say, just getting back to the earlier point, that our courts are very comfortable adjudicating disputes that have events that happen not in Canada. We do it all the time. We do it in car accidents disputes, we do it in patent disputes, we do it in contract disputes, we do it in product liability. It's very, very common. Our leading case on forum non-convenience is a holiday case where two Canadians contracted with a company that was not Canadian to travel to Cuba, and then in one case, the person drowned while scuba diving. In another case, they were paralyzed while using exercise equipment. The Supreme Court had no problem ruling that a Canadian court should determine what happened, including what happened in Cuba. So our courts have this competence, they have the power, the law is clear, but there's forum non-convenience. And so we wanted to take a good run at forum non-convenience to say that actually the most appropriate forum is Canada. And our argument was twofold. First, we believe, and our clients believe, this is a Canadian problem. We are not suing Minor Padilla for what he did in Guatemala. We are suing Hudbay for how they organized their business. And those decisions happened in Toronto, just a few blocks away from the courthouse where we served the documents. So based on that principle, we think it's a Canadian problem. We're suing the company for their management of the company, and the effects that had in Guatemala. So for that reason alone, we think it should be heard in Ontario. The second reason is that forum non-convenience is a comparative exercise. Which court is better to determine this dispute? And unfortunately, Guatemala's legal system it does suffer from a lot of problems still. So we thought on that reason alone, it should be heard in Ontario. We expected Hudbay to raise this argument. They did. We spent over a year and a half, both sides, preparing evidence. There was something like 13 witnesses, 8 expert reports. Their expert was the former Supreme Court Justice, Chief Justice of the Supreme Court of Guatemala. He came up and said everything's fine. We had experts of our own. Our clients very courageously came up in November of 2012 and were cross-examined all day by very aggressive and very competent counsel for the mining company. And they showed such grace and such fortitude that it was truly remarkable. And at the end of all that, we were all ready to go, dressed up and ready to go to court. And a couple weeks before the actual court hearing, Hudbay decided that they didn't actually want to fight about this issue. So they withdrew their motion, and in essence, they agreed that actually the most appropriate forum to hear this dispute was Ontario courts. That was a massive victory for our clients. It's the first time in Canadian history that a community like Ellistor, clients like Angelica, were actually able to get over that hurdle. At the same time, Hudbay didn't withdraw their other legal argument, which was that, actually, if you can go to the next slide. This is what a corporation actually looks like in law. And I love showing this slide because politically and economically, we think, this is actually Barrick. We actually think of Barrick as being sort of one company. But Barrick's lawyers don't think of it as one company, they think of it as this. And Hudbay was arguing, Hudbay has a similar structure. They were arguing that each of these little boxes are completely separate from all of the other boxes. And you can't sue the top box for anything that happens at the lower box. Which in law is actually quite a powerful argument. It's dating back 115 years. Hudbay went on and on about bedrock corporate law principles. And in some ways they were right. We were arguing, though, that when the top box is making decisions about what happens on the ground, they can be held responsible if those decisions were bad decisions, if they were negative decisions. And that argument works. The court heard our motion over 2 days, and then we had great submissions from Amnesty International as well. And Helica was up for that and sat through it all. And in the end, the court said that actually you can sue the top box for stuff that happens on the ground. So we managed to get over that hurdle as well. And now we're into the nitty-gritty of a lawsuit. And it actually becomes quite powerful for our clients. We're in the discovery phase, which means Hudbay has to give us all of the documents that are in any way related to the lawsuit. And this is when the tables turn and the power, we get the power. We get to demand all their contracts, all their security policies, all their emails, all of their notes of their phone calls, their private board meetings, all of that stuff. If it's in any way related, we get access to it. So we're going to be fighting over those issues for the next couple of years in preparation for a trial, which best guess is somewhere for maybe 2 to 5 years from now. I know that I've already gone over time, so I will end very quickly by just saying the impact that these decisions have had and that Angelica has had so far is that it has created real risk for other mining companies. I think that the understanding before this lawsuit is that you can't really be sued in Canada, that as a practical risk, that's not really going to happen. That has changed, and my favorite things resulted from this is that it's the law firms that represent Canadian mining companies that are telling their own clients about this new risk. So a couple more. So yeah, so there was dozens of these. They were called risk statements, strategic risk statements, and that sort of thing. And then here's one that talks about it's a warning to Canadian corporations with foreign subsidiaries. Another one talks about this being a precedent-setting decision that has implications for Canadian companies, not just those in the natural resource sector, but also in banking, manufacturing, retail, and communications. Yeah, so there's a bunch of examples. I'll leave it there for now. I would like to say that when we do go to the discussion period, it would be nice to bring Angelica up, and if you have any questions for Angelica about the lawsuit, it's a real treat to have her here, and we should really make full use of that opportunity.
Okay, you guys have been sitting for an hour, so I'm going to ask you all, I'm going to need you to do something actually. So stand up, please. Shut up. In Coast Salish style, I would like you to raise your hands and thank Angelica, thank Rosa, and thank Adolfo, and all others who have made massive sacrifices. Masicho, thank you. Thank you for your sacrifice. Please be seated. I asked you to do that because I come from Northeast BC, I'm treaty. As always, I acknowledge my presence and see the Coast Salish territory. Because I'm a moderator, I can do what I want. I have a theory. I was thinking a lot about this presentation when I gave on Friday. My concern, when we think about law, human rights, and extractivism, is that for those of you, how many are lawyers in this room? There's a couple. Okay, there's a few. I'm concerned that people in the progressive movement are using law in the same way extractive industries use land. And that case, that example, comes from Indigenous law, which is the law that my family's involved in. We took a case to the Canadian Supreme Court in 2011 and lost. You have to think of, for those of you who aren't lawyers, it helps perhaps, how many of you guys know what an injunction is? Once you guys assume? Okay, yeah, all right. Burning Mountain, very educating experience. Affidavits become important, okay. In my view, it is important to think of law as a terrain that can be exploited. I am concerned that the movement in Canada, a lot of the discourse here about extraction, has really preyed upon and used not only the suffering of Indigenous peoples, but the legal principles that Indigenous peoples present in this country. Okay, so, we talked earlier about Kaya and Rachel's work, and my concern is that if you chart the trajectory of Indigenous law as it relates to engaging with extractive industry, you see fairly cohesive and consistent resistance and counter movements in legislation and in the development of common law. And that's not to disrespect the good work that's being done in Canada. It's not to disrespect judges. There are some good ones out there. But I'm concerned that the Green movement has preyed upon Indigenous peoples and the legal principles, the legal mess that is Indigenous peoples in this country, and it is being used and abused contemporarily. I don't say that to be disrespectful, I don't say that to call you out, but if you're going to use Indians, and I use the word Indian specifically because that's a legal term in this country, if you're going to use Indians to resist because our politicians in this country don't care and we're like Indians are the last line of defense, which many very important, very serious ENGOs are kind of saying, you run the risk of squandering that potential. I'm a hunting man, been hunting since I was a little boy, and I understand the importance of kill shots. I was trained to kill efficiently and not make things suffer. So you don't take a long shot at long distance, you get close, interrupt the central nervous system. In law, because it's an adversarial process, I hope people understand and deeply reflect upon the implications of inappropriately using the opportunity you have that Indigenous people represent legally in this country and other countries. And that's why I forced you to stand up and honor people who have suffered. I just forced you to step up, and not that people are opposed to it, but take what you just did and apply it to your work. Apply it to your theory, apply it to how you engage. In my view, in this country, and this refers to a point that Patrick made in the panel on Friday, we have access to information. We have a relatively small amount of open, coercive violence being exercised against us. It's significant, particularly for Indigenous people, but it's nothing compared to what happens in other countries. For those of us here in the privileged West, in my view, there is an elevated responsibility to go past the human rights framework and engage in a more progressive way. Now, I'll explain this. Willow called me out for not being too wordy in the last presentation, so I'll try and make this a little more simple and accessible. I think that human rights and the human rights frameworks, I mentioned the Inter-American Commission on Human Rights and the requests you can have for precautionary measures when you're going to have a violent overthrow or violent engagement with an Indigenous group in the Americas. Get observers out, that's very good. Hasn't been done in Canada to my knowledge. I'd like to do it from our friends in the Snowden camp, if and when those pipelines get built. However, that use of that human rights law, that is a strategic decision that has implications and consequences. So in my view, you don't use that tool unless you have to. It is incumbent upon us as we are progressing in this endeavor to deal with extractive industry to look past kind of existing frameworks and build new ones and build alternatives. I don't think human rights law is the right choice right now for a lot of the conflicts that we see in my territory. It is a human rights issue. It's a human rights abuse. I will go into and just make one quick point about a report that was issued on Thursday in my territory and kind of some of the implications. But in my view, human rights sits over on the spectrum of resistance. You have violent reprisal, killings, and then you have kind of over the stuff like what Alain went through, slap suits, okay? Shitty, terrible, hella suffering, fucks with your life, absolutely. But they're not openly killing you, and I think both are coercive. But if you're over here in kind of this privileged place, and I say that with respect, as compared to what other people have to face in other parts of the world, don't deploy the tool that we have foolishly. You have to wait for the best opportunities. I am concerned by the trajectory of Indigenous law in this country as it relates to extractive industry, because it's being used and abused by the left, by the Greenies, by people like yourselves. I want to accuse you, I made the same decisions. I begged my family not to take that case in 2011. It's a bad idea, it's bad facts. You have to think of law as a limited kind of time opportunity, and the good work that you're doing, Corey, and your firm opens up the realm for like a little bit more work. But law is small c conservative, it does not move quickly, and there are strong legislative responses that are quickly closing doors. Okay, and that's clear. That's what gave birth to Island No More. Okay, there are very, very intelligent people drafting laws, drafting regulatory policies, drafting corporate social responsibility guidelines, lobbying at every level from the local to the national, international, opposing the kind of application of beautiful principles to defend land. Those windows are closing quickly. And I promise you this because all of us who are lawyers have to go find the few spaces where the windows aren't closed yet. And it's really, really difficult in this country. And I want to make that point clear because it's not a point that many people make. It's a point that I think is volatile. I don't mean to disrespect you with it, but it's my view. I think that genuinely you have to really engage with that implication. Don't rely on the Indians to do what you guys couldn't do yourselves, to settlers. It's not fair. And what you're doing is you're replicating, you're colonizing an opportunity, a legal principle, and taking it and using it to defend something that wasn't defended in the first place. And that's a replication of the dynamic that we're trying to oppose, which is why for those of us here in the privileged West, we have to go beyond those simplistic frameworks. In my view, the human rights law has a very important role in engaging with extractive industry, but here in Canada, where we have so much opportunity, how many people are academics? How many people are in post-secondary? We're in institution, okay? I think academy, I think academics have a massive role. We need expert evidence, for one. And I'll point out too, this is a presentation I gave recently. Yeah, that's all lovely. So I'm from the top, okay, up there. On Thursday, the second phase of the research report into the health effects of the oil and gas industry in Northeast BC was released. Lo and behold, there is a low possibility for adverse health outcomes from the oil and gas industry in Northeast BC. Yeah, okay, fair. You see this drilling rig on fire behind me. This is Neighbors Drilling Rig 14. It caught fire in 2008. It was being run by ConocoPhillips, which raises very interesting question of corporate accountability, subcontractor liability, all that kind of stuff. Great, very interesting. This thing burned for 3 days. I took this picture from the helicopter, and I'm free to use it. The company hired a very interesting firm out of Calgary called Intrinsic Resources. Intrinsic Health Services, I think was their name at the time. Their job was to conduct a human health risk assessment. And lo and behold, that human health risk assessment found there to be a low possibility of adverse health outcomes from this event. That is the same company that on Thursday released a report on behalf of the Ministry of Health of British Columbia, finding that there is low possibility of adverse health outcomes in Northeast BC as a result of the oil and gas industry. I've spoken with a few people in the crowd. I have a high expectation from academia. My expectation is that you will not allow your science to be depoliticized, because it is political. Understanding like how you do air dispersal modeling for something like this is critical. I can't do it, we can't do it, the indigenous people generally can't do it. And in time we will, you know, and I really applaud people like Willow and others who are in sciences, the hard sciences, because we need people with that understanding and grounding to engage. But with that said, all of us have a role to play, and I think when you see things like this is a human health risk assessment that came out of this, isn't it? No human health risk assessment came out of this. My cousin took this picture last summer. It's a fracking rig that caught fire, blew up. 3 weeks ago, a man was killed on a CalFrac site outside of Fort St. John. Okay, so the thing is, when you see stuff like this, one option would be to apply a human rights framework and say this is a clear violation of human rights, this is a violation of treaty rights, blah, blah, blah. And that's fine. I'm not sure that that's the right answer right now. In my view, we should be looking at the rights of the environment. We should be looking past the anthropocentric, human-oriented lens. Not that that lens isn't relevant, but that lens is more appropriately deployed for people like Angelica. Okay? We have the privilege and the opportunity to really, really be progressive in this country. You can look at the granting of legal personality of the Whanganui River in Aotearoa in New Zealand. You can look at, is it Ecuador, I believe, and the granting of, in Constitution, of the rights of Pachamama. You know, there are those kinds of initiatives. The Suzuki Foundation is pushing for a constitutional amendment, for a right to a healthy environment. Like, those are things that we can do, and I don't know if applying the human rights framework of law is appropriate for stuff like this, as much as it is a human rights issue. For people like Togastai and Frida, you guys are going to face something a lot more adverse in time. I think you realize that. My thinking is that that suffering, that potential, that risk should not be squandered. You have to be strategic, which is why I need academics doing really good research, which is why I need artists doing really provocative art, which is why I need brilliant lawyers and legal professors engaging in the development of theory, and why we need authors who are willing to speak publicly to raise ideas and change. Okay? I have a lot more to say about law and extractivism. The truth is, I don't really want to. I'm a moderator, I'll do what I want. So what I'd like to do is open it up for discussion. You have a bunch of other people, and Angelica, we'd be honored if you would join us up here, please. Come, sister, come on over. And let's have a discussion, but understand what I've said, okay? Do not use Indians and our law and the way we've been treated in Canadian law without reflecting the consequences, because there is a consequence. Okay? All right. So, open questions. Come on, you're not going to offend me. Lots of smart people here. There you go. Right, do you have? Also, we had some gender balance up here, which is important. Yes, sir.
That was a fantastic panel. Thank you so much. My name is Tim Takaro. I'm a health scientist at SFU. My focus is on environmental and occupational disease. I'm very curious about the approach that you're suggesting, Caleb, that what my
I can repeat the question if you just time this.
So I was very interested in what you said, Caleb, about not using the human rights tool at the moment here, and that other tools are better. And one of them, I think you mentioned, was the environment, certainly, but the other, I think you mentioned the death of a worker.
Mm-hmm.
And I wondered if you could comment on the workers and the role of work and using that in lieu of the human rights lens at this time.
So I'm a naturally provocative human being. I don't mean to disrespect or disregard the importance of human rights legislation and the use of human-oriented analysis to engage with the extractive industry. Okay, like, I think that human health risk analysis, public health work has to be done. As I said in the presentation on Friday, I think there are compounds that are very dangerous to petroleum distillates. You know, as a health researcher, I think those compounds are common to a lot of extractive industries. So you attack a compound, you attack diluted bitumen, you attack fracking, you attack dispersants and offshore. If you have that kind of approach, that's useful. If you couch it in human health, in the human lens, great. But my thinking is that you have to be more expansive in your application of the tools. We live in a privileged West. We can do what can't be done easily in Guatemala. I mean, do you know how inaccessible this discourse is? I mean, how many years of accumulated post-secondary education are in this room, right? Like we sit on the edge of a theoretical mountain, and we don't use it. And that's why I think the human health, the human rights framework is inappropriately applied here. Well, at least without criticism. In regards to labor and the use of labor, I think that's important. I'm just naturally wary of hierarchical structures, and I'm very wary of alliances because my people have been burned many, many times. With that said, we all have a role to play, so I don't mean to disrespect the role of union labor and its massive part in kind of the development of what we have here. I'm wary of it. You know, we're dealing with systems change, and so asking someone like my cousins who work in the patch to, like, you know, they make the sacrifice. They're the ones on the front lines. They're the ones who can't feed their kids. You know, and like we here in the privileged South with like very developed social networks and kind of progressive theories and lots of education, we can, you know, make decisions. You know, if I want to live like a hobo down because it's ethical and I want to eat vegan, like, great. But try doing that in Northeast BC, where I'm from. You know, it's not going to fly. It's -40 in the winter. You can't buy groceries like that. So I'm wary of using those tools. That's my main point. Just be critical. You know, because I expect and I hold you to account for witnessing what you've done. That's Coach Sailor style. You know, I think that you all have an obligation, as do I, and I think that being critical is kind of the first step in exercising living up to the obligation. Sorry, long-winded lawyer answer, a little quicker. We're going through this group, is that? Yeah, sure.
I'm a preventive medicine physician who turned away from tobacco to look at ecocide, which is a much more serious problem, and which we are, public health people are profoundly illiterate in. And I can tell you, the health risks, the classical public health risks of fracking is really minimal. The ecocidal risks are astronomical. And we are pretty much ecologically illiterate and function that way. So
one of the question to Indigenous people, I think, are fairly literate in the ecosystem. I would agree.
I mean, as a society, in terms of laws. I want to say that I have no problem. I want to challenge you back. I have no problem in Aboriginals taking leadership. Not just in this country, but on this planet. Because one of the things, I mean, I'm not ecologically literate. I'm gesturing in that direction. But one of the things that in my own evolution, I knew from tobacco that people are not rational creatures. So you have to be very careful about rationality or systems of law, any kind of law, delivering us. We are visceral, heart-led people. We are spiritual people. That's what will move us. And I would not count on academia and the tribe, the fossilized tribe in academia to lead us. So I have a very specific question. I just want to say that I think that Aboriginal folks have the technology, namely spirit-led behavior. That is what is going to eventually lead us wherever we're going to go, either up or down, or sideways. Okay, I have a very specific question. There is an international effort called Eradicating Ecocide, being led by Polly Higgins out of the UK. She's been here twice. I haven't heard anybody even used the word ecocide in the last 2 days. And one of the examples she gave was the trial of, the mock trial of two tar sands executives, and the mock trial applying a law against ecocide found them guilty. There was no law against genocide when I was 15 years old. There was when I was 20 years old. There's no law now against, international law against ecocide, and I think that it's very incumbent on everybody to pay attention to an international, development of an international law against ecocide. And that would help.
Okay, so
Please respond to that.
Thank you, Jay. So do the panelists want to make a comment on that, ecocide specifically, or alternatively, the development of international legal principles? Do you want to touch on that? Does anybody? Do you want to take a stab at that? Okay, I think we're going to just have to let that one sit in the parking lot, but thank you for your comment. The development of international legal law, the development of international legal principles is a long game. That's the, oh, sir, you got to respect the group. You got to respect the group.
Okay, let's
So
just say eradicatingecocide.com. Eradicatingecocide.com.
Thank you for coming. Yes, sir.
Yeah, we're like we presented yesterday from the Minnesota camp, and we're like on the forefront of an inevitable head-on crash with the Canadian state and industry, who basically control what the Canadian state is doing. The reason why we're occupying the territory now is because we want to set precedents in a court case, which would have to get launched by them. But we would want to set precedents on ensuring that we change the legal processes that exist in the legal institutions here in Canada. To date, Aboriginal people, whenever we've gone to court over our lands, the onus has always been on our people to prove our title and our rights to the state that imposed itself on us. By merely living out on the territory and making it our home, protecting the integrity, the biological diversity, integrity of the territory, we hope to set precedents, and we're going to set precedents in ensuring that the onus is reversed. Because it's going to have to come from the Crown. The Crown is going to have to prove why they have title on our territory, and we'll have to compare the two pieces of evidence. We've already gone through a large part of that step with the Delgamuukw case, and we're preparing for part 2 of Delgamuukw. But we're looking for any kind of advice or any kind of feedback from people who have a scholarly background or a legal background or academic background on how we can kind of present that forward. And I really like your analysis of what you said, that if you're going to employ some legal tools, do it in a timely manner. And that's exactly what we're doing. We're sitting back. We know exactly what is at stake right now. You know, against our body, against our people, and against our culture, and against the biological integrity and diversity of the territories that we're protecting. And that's what we're about. We're not a human-centric model of Indigenous people standing up. Indigenous people are never human-centric. Indigenous people are there to protect the land because we are the land. And I think it's really important that we kind of move away from that dialogue when we're talking about legal challenges with Indigenous people, because that's really what we're representing. We're not representing us as other human beings. We're representing our position in a very complex and diverse ecosystem. And that's where we need to go as a human race.
To the co-panelists, thank you, Dover staff, for the comments. Does anyone want to talk about onus and onus shifting? I'm sure there's a significant onus issue in KI. Or even just talk about kind of the procedural environment when it comes to these kinds of cases. We can talk about
I know practice law, so it's a little bit difficult to kind of get into all the procedure stuff, but just from that case itself, obviously it came from Platinx, right? Like KI didn't it's not that they decided that they didn't decide, oh, let's go to court and have court recognize our law. It's that they used their law in defense of their territory, in defense against this idea of the injunction. So the proceedings are just, and then I think that what happened is, as they went along, they saw that Canadian law could not respond. I mean, it had that little moment at the beginning, which was it was a kind of a celebratory time because of that victory aspect where the judge really seemed to listen to what they were saying. But Canadian law couldn't go farther than that. And when it couldn't go farther, when it all became quite narrow, when it became the right to be consulted, which is not what any treaty says, and that's nothing that anybody would have agreed to, and that's when they stepped back from the court. And I think that that was a very strong position to take. I mean, I don't think it was an easy decision to take. I should say, I speak as a friend to the community, but I don't speak for the community. But, you know, they did make that decision, and then they were on a much different road. And after that, it was very clear that Canadian law was a very oppressive force. So I sort of can't talk a lot about the procedure, but I think it's really important. Each step, right? Each step, they made a different decision and reflected on what it meant for them. And my understanding when I speak with members of the community is also them and their land, you know, as one.
Okay, I'd like to ask 3 questions in a row, quick succession, no chemtrails, no tirades, no rants, just quick questions. And also remember that you have a massively capable panel to my left. I'm questionable, but these guys are solid. So, like seriously, take it in. Elaine's been through the ringer. Okay, these guys are doing it. She lived it. That's badass too. Like, try. 3 questions. No one will respond.
Okay, I just wanted to get to something you were talking about, one of you were talking about earlier when it came to the mining companies and the human rights abuses. I actually have not a strong connection, but a close connection to a particular mining company, or mining supplies company that probably does business with some of these ones in other countries. And I wonder what I can do perhaps to put pressure on them. The company is Team Thiessen Inc. Team Thiessen USA Inc. A friend of mine, his father owns this company, and I don't know much about it except for that they do a lot of business with a lot of the extraction industry, and I wonder what I can do perhaps to put pressure on this company to shift their...
We'll get 3 questions in a row, then we'll respond. Okay. So I'll get 3 questions, and then we'll kind of respond through it, guys. So we got about 15 minutes, I think, and I'm a ruthless moderator. Yes.
Hi, so I'm Professor Karen Bucker from the University of British Columbia, where I'm Director of the Program on Water Governance. And I want to just briefly thank you all for your devotion and in some cases your suffering, just appreciation and gratitude. I have a quick question. It relates to my area of research and expertise, and it relates to something that some of you were saying regarding strategic use of the law. I would like to ask you to what extent you think the use of environmental law and water law specifically can be mobilized in all of your cases. There is international jurisprudence, there's the public trust doctrine that would be widely applied in the US. Even in Ontario, there's the Surface Water Protection Act. The Clean Water Act in 2006 mandated watershed protection, mandated planning processes that would allow water protection to trump any land development, from a dry cleaner to a mine. Sadly, it's only been applied in southern Ontario, as you probably know. So there are many openings within water law or environmental law more generally to pursue what you might want to call SLACs, strategic lawsuits against corporate crime, which I wanted to slap. So I'd love to hear about that, and I'd also love to hear a practical suggestion from each of you about what we could leave the room and do. I'm an academic, so I do research, but there may be many things you want to ask for. But I hope this conference gets action-oriented by the end of the day, and would just love to hear practical suggestions. What can we do for you?
And one more question, and then we'll do a panel response.
Good afternoon. My name is Bill McIntosh, and first I want to thank this whole group. I just got here this morning, so I apologize if my question has been answered. I appreciate very much the good advice that you were giving about not using your human rights cause of action lightly. My question is about using property law, using the Chilcotin decision, and I'm wondering why I haven't heard about that this morning. So the decision was historic for Canada. The Chilcotin were given title to a huge territory in their lands, and with that though comes some wonderful doctrine from the Supreme Court of Canada that is a very powerful tool where it seems to me that you're using the legal system and you're using the strength of your law to your own advantage and just focusing on the property right that's now been given. And I'm very interested to hear the
Okay. All right, thanks. That's property law code. I think myself. Okay, I can jump in on that one. Okay, wow. First question on what to do about subsidiaries.
Yeah, so I think the question was, it is quite common in Canada for people to have various links to mining companies, whether that's as employees or as shareholders, or they have family members who are involved. And I think it's really important to know that this is a wide struggle and a broad struggle, and I think if we're actually going to make real strides, they have to come from everywhere at once. Which means that, just because somebody happens to be involved with the mining industry doesn't mean that we don't talk to them. I think it's really important to engage those people and to themselves engage so that, the next general counsel of the mining company is more willing to raise this with their bosses. There are shareholder activism. I have my critiques of the worth of shareholder activism, but I'm glad it's happening. And so I think it's really important for mining companies to hear about it from all different angles. And as that happens, they will understand that it's not something that they can kind of get away with. So yeah, I encourage people to talk to whomever. It's a bit of a weird thing that when I attended law school, I sort of entered this weird world where there's all sorts of people who are, for a small moment, colleagues, and then you go off and do all sorts of other things. And it's fun to talk to them. And like some of them, what do they do all day? They do like big deals between mining companies, so they do mergers and acquisitions, and you can get a lot of information. And you can also like subtly poke and prod, and I think that's an important thing to do. And I think Angelica might have had a thought on this question.
Buenas tardes. Quiero responder un poco sobre las preguntas que se están haciendo. Primero, alguien preguntó qué debemos de hacer. Aquí, para mí, lo que debemos de hacer, algo que yo escuché, no sé, en un panel de estos días, que hacían la invitación que los pueblos indígenas que viven en la ciudad regresen a cuidar su territorio. Es muy importante eso, es cierto. Pero además de eso, hay algo que dijeron ahí también, alguien. Aquí lo que queremos no ser enemigos con nadie, lo que queremos es tener una paz, una tranquilidad en cada pueblo, pueblos indígenas o no indígenas. Creo que lo que debemos de hacer es rescatar nuestro territorio, sea indígena o no indígena, porque las empresas andan viendo en dónde hay riquezas. Ahí no están buscando si solo el pueblo indígena, no. Lo que debemos, creo yo, unirnos. Respeto a los abogados que están aquí. Está bien que ellos hayan estudiado, entonces saben cuáles son las leyes. Debemos de tener mucha conexión con ellos para no usar la violencia, escuchar cómo se debe de trabajar. Uno, Lo otro, hay leyes que deben de amparar el derecho de los pueblos indígenas, como el convenio 169 ratificado en las Naciones Unidas, en donde habla que en cada territorio de los pueblos indígenas las empresas deben de consultar si quieren o no quieren que se trabaje en la empresa. Pero nosotros en nuestro país, para ellos no vale nada esa ley, ese convenio. Entonces yo creo que eso hay que analizarlo, hay que tratar la manera de entrar en resistencia, pero siempre pacíficamente. Y otro que hablaba ahí, alguien alguien que preguntaba que trabaja en una empresa, ¿qué debo hacer? Para mí, todos tenemos necesidad, pero siempre y cuando, si está en la empresa, mucho ojo ahí, que traiga la información para nosotros, para los pueblos, para su pueblo, para su familia, cuáles son los daños, los impactos al medio ambiente. Es muy importante también, entonces, porque de ahí podemos ver qué está pasando en esa empresa. Gracias.
Okay, I may miss a few things. The first part she said was she believes she heard in an earlier panel about the importance of Indigenous people that are living in the cities to also return to their traditional territories and get better connected with their lands in order to better defend them. And she does think that that's an important point to make, but she also wants to underscore, again, that this is not a struggle only of Indigenous people, and that it's important for people to recognize that we all belong to the land, we all come from the land, and we all have a responsibility to defend the lands. So it's important for people wherever they are to organize and take a stand in defense of the lands and support those people who are on the front lines on the lands. The other part in regarding legal struggle, she sees the legal part being a very important aspect, and in her country often the sort of only alternative to a violent struggle. And so it's very important to, she believes the lawyers have learned a lot and know a lot of avenues, so it's very important to work in alliance with them. But again, it has to be done in conjunction. You can't sort of sit back and wait for the lawyers, but to be doing stuff at the same time. That in Guatemala, the big challenge with the sort of movements in defense of the land is keeping them peaceful. That when the resistance becomes violent, it opens the door for a much heavier repression than already exists. So keeping non-violent resistance is a big challenge because there's a lot of valid reasons for people wanting to go the other way. There was also a response to the question about if you're working or if you have links to people working with companies that are in mining. Again, it's not something to be ashamed of if you're working for a corporation. There's recognition that everybody has to make a living, and in their communities too, there are people that end up working for the companies. But you can be an ally within those companies, almost like being a mole. That it's important to see what's happening, and often from inside the companies you're seeing what may not be visible from the outside. So if that information can be shared with activists, with lawyers, it gives a sort of way up for people involved in the struggle. Any Spanish speakers, let me know if I forgot something, because I'm sure there was more there. Ruth, did I miss anything? Oh, yeah, and there was some touching about international law and processes. And for Indigenous peoples around the world, a really important one is Convention 169 of the International Labour Organization that talks about free, prior, and informed consent. And it's one that is being used as a banner in many countries around the world by indigenous communities to defend themselves, but it's one that she said in her country, unless they are pushed, the government, although they're signatories of the convention, completely ignore it.
Okay. So maybe, does anyone on the panel want to respond to Professor Backer's question about environmental law and water law? Do you want to, perhaps what's happening in Quebec on environmental law, or is that?
I could talk about nothing we do.
Yeah, okay, well then, and then alternatively, just practical suggestions from the panelists, and I'll post it off. Maybe we'll have one more set of 3, and then we'll call it.
Yeah, there was a question on what can we do. Well, I would say regarding to the fact of writing, that it should be clear in our mind when we do a book, I think, that law, including the system of law and the power of law is just a domain among other within the social sciences, the humanities. Once I was very afraid. I saw a lawyer and I was, well, I mean, I had a friendly conversation with him, it happens. And it does. Well, I was just saying that I mean, law is just a domain among others. There's psychology, literature, philosophy, sociology, and so on. And he said no, and he made that sign, law is everything, it covers everything. And when it's really the way some jurists think. And well, I was afraid because I said, well, why would the judge explain to me what's relevant in a philosophical essay or a sociological essay? And this is what I had always to explain when I was in that trial, that, well, there are methodologies that exist in our field that, and I mean, just to explain how, I mean, if we think throughout this domain of law, everything becomes so rough. I mean, my lawyers were explaining to the judge in order to fit in the jurisprudence that I was a journalist. Because if not, I wouldn't have been seen. And so you see how rough it becomes. So I have the right to a fair comment. And so I had to deal with a deontology that isn't mine, because if you're a journalist, you have to quote the counterpart and do a balanced inquiry. And it wasn't, I mean, I just want to say that when we're facing the legal system and judges that are former lawyers that work for big law firms and that know much more about corporate interests than other kind of interests. I mean, my publisher, for instance, had to explain that when you launch a book, more often than not, it's a commercial bid. I mean, you don't make money with books, but we do launch books that we know that won't be profitable because we're not selling sausages, you know, and you have to explain all this because it's not their culture. And well, just to say that we have to fight to defend some approach, methodologies, and I mean the freedom of speech in a very convicted way.
Practical suggestions, takeaways from the group. As the professor, right?
Yeah, practical suggestions. I think one thing that I just want to follow up with Alain's comment a little bit. One thing that I really try to do is I think that law needs to be made intelligible to people. It is only one domain, and I think that it can be explained in plain language and people can understand how it works. That just, it's something that we need to put effort into. As for something practical to do, you could, if you want to find out, KI struggle is ongoing, right? It hasn't ended yet. So go to www.kilands.org and you can find out what they're doing and you can support their efforts. Thank you.
Yeah, one very practical suggestion I can get. I guess there's two things that really help this struggle from a Canadian perspective. One is that our clients in Angelica have been very clear from the start that one of the main things that they want from bringing this lawsuit is to have their story told. And it's great that Angelica tells it here, but all of you can rebroadcast it. And that would be fantastic and practical. And then the second thing is Rights Action is a unique organization that does some really fantastic work. They're one of the few Canadian NGOs that actually will fund on-the-ground struggles. So that when Angelica's community needs to get transportation to go to the criminal trial, that funding will be provided for that. When there is a ceremony to commemorate Adolfo's life, there will be money and funding for that. So it's a small organization and it can use any support that you can give. And their address is rightsaction.org. So I guess those would be the two quick practical suggestions.
Something practical that she can offer the group to take away?
Yo solo agradecerles a ustedes que han puesto la atención y ojalá que les quede en la conciencia que hay que hacer algo, ¿verdad?, para defender nuestra tierra. Digo nuestra tierra porque no solo mi tierra, tiene que abarcar el mundo. Y también gracias a los abogados aquí, en especial a mi abogado, quien es Cory, pues está trabajando arduamente. Muy joven, tal vez no van a valorar su lucha, pero está batallando en las salas, en las audiencias, y esto estamos muy agradecidos. Nosotros lo hemos protegido con nuestras ceremonias mayas. Y de último, tengo algunas copias de defensora que la persona que lo trabajó, quien fue Raquel, me dio algunas copias. Si alguien desea tener esa película y verlo detenidamente, la realidad que hemos vivido, tengo algunas copias ahí todavía que son $20 cada uno. Gracias y con permiso.
So first, I want to thank everyone again for their concern with my struggle and for the struggle to defend the earth, not just my piece of it, but that goes all around the world. I'm grateful to the lawyers that are engaged in this struggle as well as our allies. All the lawyers represented here, and particularly my lawyer, Cory Wanless. He's showed himself to be indefatigable in the courtroom. He's young, but he never gives up. And we have had many of our Mayan ceremonies to try and build a protection for him, because we think we need to protect him as well. In terms of what you can do in terms of getting the word out, I think some of you have seen clips of it here. The film Defensora, about the case and about the struggle of the Kekchi-Maya in the El Estor region. Angelica still has some copies of it that she is selling. What she would really like, apart from you watching it and getting a really clear picture of the story, is to show it as much as possible to get the information out. So that's an important tool for reproducing the struggle.
The dubious distinction of finishing it out. My apologies to the gentleman waiting so patiently. We don't have time. I apologize. I've been told we have to shut it down. I have to answer 3 questions and offer some takeaways. Behind me, I put up a treaty symbol. This is a peace medallion, Treaty 8. I did this because I'm a coyote-like creature and I like embedding laws and ideas in media. That medallion is there to signify the signing of Treaty 8, which ceded the land I'm from. It is worn, it is beaten, but is not gone. And I just think that's important. I think it's important to contextualize and not be overly defeatist or negative with the things we face. And I think this medallion, as brutally treated as it has been, both practically, physically, but also theoretically and spiritually, there's still good things there. Professor Backer on environmental law and water law, in my opinion, water law is the future. I know you work in that area, as do I. I think that water law in this province is going to come to a head in a very serious way because you have the intersection of energy with fracking, LNG, Alberta with the tar sands, and you've got the hydroelectric development, right? So in BC, water law is key.
Climate change.
Climate change is huge. Climate change litigation, international climate change litigation, very good ideas. International litigation, absent a localized strategic engagement, means very little. You have to plan everything together. To deal with an interconnected system, you have to be interconnected yourself. And you have to be tactical, and that's the problem. That you have standalone initiatives that don't work together, at least in my opinion. For Bill, your question on product launch, Chilcotin, and actually this is a reference to Alain's point. The BC Court of Appeal Justice who authored the Chilcotin decision that was overturned in the Supreme Court, he was the opposing counsel for the Delgamude case. And he lost. Becomes a judge 30 years later. Not 30 years, 20 years later, 25 years later. Becomes a judge. Brings back the very legal doctrine of localized territory. You know, you have title over like the rocky outcropping that you speared the salmon on, and that's it. That idea, that legal interpretation was brought back from the dead by a lawyer who lost. And I say that respectfully, because these people are very intelligent and I don't believe they're evil. But it's interesting to see how old ideas come back. And so Alain, your point about the judiciary being drawn from lawyers who work in an adversarial process, that's interesting. You see that in the Chilcotin decision, at least the Court of Appeal, which was overturned, thank goodness. On the Chilcotin decision and property law in general, the problem with Chilcotin and using Aboriginal rights, of which title is a subset, interestingly, is that there's a sparrow justification analysis. So at the end of the day, even if you have title, it can be infringed upon. So even if you get that far, and understand that the Chilcotin League used to behead people for coming in their territory. There is a fact pattern there that is 100 years long, longer, time immemorial. And they're the first ones. It took them 30 years to find title in this country, and we don't have 30 years to wait, which leads me to my final point, some practical suggestions. One, support practically. I'm developing a board. I'm the executive director for Keepers of the Water. I'm developing a board right now. A very intelligent man said, your board members have to give resources, get resources, or get out of the way. So the practical suggestion, one, if you want to support this stuff, give resources to the Unistowin camp. Get resources for them or get out of the way. None of this collectivism bullshit, none of that stuff. Don't sit on your ass and watch this stuff happen. Get out there. A lot of people were there at Burnaby. You know, you have to step up and support, but do so strategically. So that's a practical suggestion. Give to the direct action, the front line. You get for them or you get out of the way. Real simple. Second point, for those of you in academia, understand that your research is critical. I believe in the sciences, I just don't believe in kind of the underpinning theories. I think there's good things to be done. So for those of you who have post-secondary or higher, use your skills, use your research. What you do is important, and though it's embedded in a neutral environment, make it count. Look at the Northeast, look at the tar sands, look wherever, there's problems everywhere. Use your research. And of course, the final practical suggestion, support Angelica, buy the coffee, use the opportunities afforded to you in this environment to do something practical. And with that, I must you for your time, I must you co-panelists, let's shut it down.